Good morning. This is Layli Miller-Muro. I'm the CEO of the Tahirih Justice Center, which provides free legal services to immigrant women and girls fleeing human rights abuses. And we do this through our offices in the Washington, D.C. area, Houston, Texas, San Francisco, and Baltimore. And so we're on the front lines with regard to helping immigrant women and girls specifically navigate all that's happening in the United States and in the world right now. And I'll do my best to once again explain what's currently happening. It's very fast moving, literally hour to hour. Things are happening that will change the legality of these so-called travel bans, but in fact something quite significant relative to the travel ban, but also relative to legal history in the United States happened last night. So I'm going to do my best to try to explain what's going on. First, I want to make it absolutely clear that all that is going on right now, meaning in the last 12 hours with the Washington court, only affects one of the three executive orders. So there are three different executive orders which all affect immigrants. One of them deals primarily with people outside the country trying to come in. The other two deal with immigrants who are currently residing in the United States. The executive order that is at issue only relates to the one that affects people who are outside of the United States trying to come in. So to be clear, when people talk about executive order being overturned, it's really only one of the three, and the other two also have very difficult, damaging content to it. But I'll focus on the one. First, what is a temporary restraining order? A temporary restraining order is a temporary order. It has a time limitation to it that's established by the judge that issues the order that basically says, I'm going to halt the enforcement of this executive order pending a full-blown hearing on the merits. In order to get a temporary restraining order, you have to prove that you are likely to prevail. That's the legal standard. You have to prove that you're likely to prevail on the merits. But given the emergent nature of temporary restraining orders, there's never time to fully argue the merits. And so that's why they are called temporary restraining orders. They will end. They have a limited time band. And in this case, the judge said he wanted to hear arguments on the full arguments on the merits of the case on Monday late afternoon. So we know this order also has a temporary nature, but that's the whole purpose of temporary restraining orders. You have to simply prove that you are likely to prevail on the merits. So it's basically the judge saying, yep, I think you got a good case. It's not a ridiculous case that you're bringing. You're likely to prevail on the merits, and so I will issue a temporary restraining order to halt the implementation of what's being challenged temporarily. So this is temporary, and I'll explain what's going to happen next in this order. But first, to focus on what was decided last night. So a Washington State federal court did agree to implement a temporary restraining order that is national in scope. This is different than the other court orders that have come and gone all over the country around this particular executive order. So it has national scope. He made the decision based on the arguments that the plaintiff presented. I read the 17-page plaintiff's brief last night. This case was brought by the Attorney General of the state of Washington. And so he brought it on behalf of the citizens of Washington state. And of course, that included corporations that are being financially harmed by the executive order, Amazon, Expedia, Microsoft. He also brought it on behalf of universities whose students are unable to enter. And then interestingly, the state of Minnesota also joined in the suit. So in the plaintiff's brief, there are arguments by Minnesota about how Minnesota was also being affected. So the fact that the Attorney General himself brought the suit on behalf of the state was itself a little distinguished from other lawsuits being brought around the country, because mostly the other lawsuits were being brought by ACLU, the American Immigration Lawyers Association. These are private individuals who only have authority to bring lawsuits on behalf of individuals. So it was being brought on behalf of individuals that were specifically harmed or affected. And then the jurisdiction in those other lawsuits, in the decisions made, only applied locally. So there was a Boston federal judge, for example, that issued a temporary restraining order, and it only impacted flights coming into Boston. That restraining order, of course, expired because, as I mentioned before, they all have a limited duration because they're meant to be temporary. And then when arguments were made on the underlying merits of the claim, the judge declined to make that a permanent order. There's still lawsuits going on in Boston with regard to it, but in terms of that emergency restraining order, the temporary nature of the one in Boston was allowed to expire because of the actions of a later judge in that case. This case is different because it was the lawsuit was brought by the Attorney General of the state of Washington on behalf of its residents, its businesses, and its universities. And as I mentioned, the state of Minnesota also joined in this lawsuit. The judge's decision was based both on constitutional and on statutory grounds. So people often talk about challenging this executive order and other executive orders that have been issued on constitutional grounds, but it's important to mention, and any good lawyer will of course bring multiple claims, and there were lots of kinds of claims that could be brought in this suit. So specifically, constitutionally, the Fifth Amendment and the Second Amendment were invoked. The Fifth Amendment is the Due Process Clause, and so where you have people whose visas have been revoked, and as we know from news reports, anywhere between 60,000 and 100,000 visas were in fact revoked. Those visa determinations should be happening on a case-by-case basis, but to revoke them in the broad way that they were, an argument is being made that that was in violation of due process. The Second Amendment is the Establishment Clause, and that basically means that's the Religious Freedom Clause. And I was really impressed with the legal brief. For anyone, particularly if you're a lawyer, but if you just like good writing, I would really recommend reading the briefs in these cases, both on the government side, and the government did a great job defending the executive orders. I think it's important to note some people have asked the question, did the federal government lawyers roll over because of the former acting attorney general's instructions to not defend these executive orders? And the answer in this case was clearly not. The government attorneys did a great job in arguing their side of the case. They are smart, they worked hard, they did their research, and so no one can claim that this case was not adequately defended or adequately argued. Similarly, no one should claim that this was a political act. The judge in this case was a Republican, and the Attorney General of the state of Washington has brought similar lawsuits against the Obama administration in other executive orders that he issued. So this is a legal question. It is not a political question. And I thought it was quite beautiful to read the briefs in both cases because they were argued on issues of law. So the Second Amendment in the Constitution, the Establishment Clause, was also argued, and I thought it was fascinating in reading the brief how much evidence they had that this was in fact a Muslim ban. They argued, of course, that the 7 countries targeted were not causally related to any terrorist act that's ever happened in the United States, and then they cited in great detail quotes from both President Trump as well as Giuliani and a number of other people who were involved in writing or developing that executive order, where they were very overt and transparent in their intention that these executive orders constitute the Muslim ban that was promised during the campaign. So that was a lot of detail. It was argued in this brief. Then the other legal grounds were statutory, specifically the Discrimination Visa Procedures of the Immigration and Nationality Act, which basically says that you cannot discriminate on the basis of religion and a few other grounds, and then they argue that this does. And, well, 1, 2, 3, 4, 5, 6. There were 6 statutory grounds. I won't go into all of the details, but this case was both brought on constitutional and statutory grounds. Okay, so what is the difference between this and other lawsuits that have been brought? I already mentioned that the other ones were being brought largely on behalf of individuals or organizations, although they were making some of the same constitutional and statutory arguments. And then, most importantly, the decisions in these other lawsuits, which are diverse. Some are losing, some are winning throughout the country. But in any case, all of those decisions, the jurisdiction that was indicated by the judge issuing that decision was local. A huge difference is that the Washington state imposed this decision nationally. The reason he could do that is because immigration law is federal law, and there was a precedent court decision under the Obama administration. So what happened there is he issued an executive order to implement something called DAPA and DACA, which basically means that children who are in the United States, I'm going to do a great injustice to my explanation of this. I'm going to back out from what that case was. Essentially, the reason the Washington state judge was able to use this Obama administration DAPA and DACA precedent-setting case as grounds for his national imposition of his executive order is that in that instance, largely Republican attorney generals all throughout the country argued and won that because immigration law is federal law and must be applied consistently throughout the country, a local federal judge's decision should apply nationally to ensure federal consistency of immigration law. So perhaps ironically, the precedent in that decision brought by largely Republican attorney generals during the Obama administration was now used in this case to allow this executive order to have national precedent or national enforcement capabilities. So what is going to happen next? The White House, of course, has said that it would appeal the case, and so there will be an appeal. I think hour by hour, we're going to see that appeal being filed. Then there will be an argument on the merits. So the temporary restraining order itself will be appealed. But then late afternoon on Monday, the merits of the temporary restraining order, because remember, all you have to prove, not all, it's a high standard, you have to prove to get a temporary restraining order is that you're likely to prevail on the merits. So Monday afternoon, they're going to have an argument in court on the merits. And that is when the judge will then make a determination that this restraining order should be permanent. Of course, that will be appealed. This is clearly going to go to the Ninth Circuit. It's conceivable that this will happen within days and very, very quickly. Because there are other decisions throughout the country that are divergent in their conclusions, and simply because of the important nature of this case, it is 99% certain this will go up to the United States Supreme Court. Now, this is where it gets really interesting because, as you may know, we do not have 9 judges currently on the United States Supreme Court. We have 8 judges. That means that numerically there is the potential for an even split on the court in their decision on this. So what happens if there is a 4-4 split in the decision on this case? What happens legally is that the Supreme Court decision means nothing. Well, clearly, or the judge's opinions, I'll say, mean nothing because they have not been able to come to a majority decision. And then the law of the court immediately under, the most recent court before the Supreme Court considers it, their decision becomes law. So the Ninth Circuit Court's decision in this case may end up being national law if it goes up and if the Supreme Court cannot make a majority rule decision in this case. So it's all extremely interesting, legally fascinating, and very consequential to hundreds of thousands of people who are being affected by this. So the last thing I'll address, and then I have to go take my daughter to Taekwondo, is what happens now to people who are waiting. The Tahirih Justice Center is advising, we have several clients in Iran right now waiting to come to the United States with green cards. We're telling them to get on the airplane now. At 9 o'clock last night, Customs and Border Patrol, even before the White House issued any public statement on this court decision, had a meeting with all the major airlines to announce that it was going now into its computer system to reinstate all of the visas that have been revoked. And so the airlines were being instructed by CBP, Customs and Border Patrol, at 9 p.m. last night, immediately following this court decision and before the White House came out with any statement, to go ahead and let people on the plane, and that they were going to begin going into the computers to reinstate the revoked visas. So there may be like a window right now where people can actually get on planes and come into the country. We have a client who needs to be reunited with her children, and we're instructing her to get on the plane today, this morning, if she can. So there may be kind of this valuable window, essentially. Yesterday, I was advising people to not travel if they're permanent residents from these 7 affected countries. Now, I would say, like, get on the plane as soon as you can, because literally hour by hour, this court decision may change. The White House is going to appeal the decision. So it's an hour by hour thing. But currently, right now, it looks like people with green cards and other still active visas can get on the airplane and come to the United States, and CBP appears to be complying with the federal court order. So that's all I know. A lot has changed. Something might have changed even as I was doing this video. I hope you have a great day, and now I'm going to go take my kids to their morning activities. Take care.